Hello, everyone. Welcome to today's webinar, Navigating the EU Packaging Regulation, Expert Insights and Analysis. Before we start discussing the packaging and packaging waste regulation, I will just provide you with a little bit of orientation about the webinar platform, and then we can dive right in. So the webinar slides are available to the left side of your screen, along with a few helpful links if you would like to explore and learn more about compliance and risks and how we can help simplify and accelerate your compliance processes. We would like this webinar to be engaging, so please send us any questions you may have, and we will aim to address them during the Q&A session at the end of the webinar. But also, if we don't get to answer your questions during today's session, then we will follow up with you directly. If you would like to submit a question, please use the Ask a Question widget on the left side of your screen. And at any time, if you are interested in having a member of our team follow up with you, please do not hesitate to use the Start a Conversation button at the bottom of your screen. And lastly, the webinar recording will be sent to you within 24 hours. So my name is Ani Nozadze. I am a Senior Regulatory Compliance Specialist and Team Lead here at Compliance and Risks. And today I am joined by my wonderful colleagues, Frida Wuschner-Gubbins, who is a Senior Global Regulatory Compliance Specialist, also here at Compliance and Risks, with 12 years of experience in the regulatory compliance sector. And since joining CNR in 2014, Frida has worked with global regulations across a diverse range of product categories and industries, developing a particular interest in compliance requirements for cosmetics, packaging, single-use plastics, and the transport of dangerous goods. And she holds a Master of Science in Environmental Health and Safety Management and a Bachelor's in European Studies in German. Hi, Frida.
Hi, everyone.
And we also have Connor O'Donoghue, who is a regulatory compliance specialist in the global regulatory compliance team here at Compliance and Risks. Connor supports clients with their compliance obligations in relation to packaging, RoHS, and anti-bribery and corruption. He holds a Bachelor of Law degree and a Master of Laws in Environmental and Natural Resources Law. Hi, Connor. Thanks for joining.
Hi, Annie. Hi, everyone. Delighted to be here.
Thank you. And we also have Ruan Doherty, who joined Compliance and Risks team in 2023. And in her role, Ruan monitors and analyzes global regulatory developments across various industry sectors. Ruan's work is concentrated on topics including packaging, single-use plastics, and ESG reporting. And her focus within packaging and single-use plastics includes regions such as the US, Canada, South America, and the Middle East. And she holds a Bachelor of Laws and a Master of Laws in International Human Rights Law. Hi, Ruan.
Thanks, Annie, and thanks everyone for tuning in today.
Thank you. So just before we kick off the webinar, I will provide a bit of information about compliance and risks for those of you who are joining us for the first time, because I know quite a lot of you are probably also already customers of compliance and risks. So here at Compliance and Risks, our mission is to help ensure global companies have the tools and the information to build safe and sustainable products in a world full of change. And we are the trusted product compliance technology provider for the world's leading brands. We have spent 2 decades honing the digital tools, the expertise, and the content that you need to stay ahead of this dynamic regulatory landscape and prove your product's compliance, helping you protect your brands and drive your growth. So on our platform, which is called C2P, we have a comprehensive historical database with over 115,000 regulations, and with global regulatory coverage and expertise across more than 10 industries. Our team of regulatory experts is always here to assist you, and our 3 presenters today and myself are part of that team as well. Our team has quite varied experience and collectively speak 28 languages, and we're also fortified by our 30 knowledge partners. So C2P is designed to keep global organizations on top of regulatory changes and their impact worldwide. This includes early warning alerts, impact probability, productivity workflow tools, and much more. So reach out to us if you'd like to learn more about how this tool can help you. And with that, we can take a look at our agenda today. So today, Frida, Connor, and Ruan will be discussing the EU packaging waste regulation, or PPWR, providing the current implementation status of the regulation, addressing common questions based on some EU issued guidance and FAQ documents. And they will also highlight some gaps that still need clarification, perhaps, and we'll also speak about the implementation of the regulation in the EU member states. So I will hand you over to Connor, who will cover the current implementation status of the regulation and some common customer questions.
Thank you, Annie. And thanks again to everyone for joining us. So, as Annie said, in my segment, I'll just cover the EU packaging regulation and some of the latest updates that have occurred in recent months. And I'll also discuss some of the most common queries that we've been receiving from our own customers, particularly in relation to the requirements that are going to be entering into force from this August. There's a huge amount we could talk about, but we don't have a huge amount of time, so I'll just dive straight in. So, as I'm sure most or all of you probably know, the regulation will generally apply from the 12th of August this year. And then over the coming years, we'll have over 20, maybe 30 compliance deadlines within the regulation, which will range all the way from 2026 up to 2040. So in the slide here, I've listed some of the latest updates. So starting in December, we had, as part of the proposed environmental omnibus package, a draft regulation was proposed to suspend the requirement to appoint an authorised representative for EPR until the 1st of January 2035. Actually, public comments are still being accepted on this until the 7th of this month, so that's 2 days' time. And then in January, we had the publication of the JRC, so the Joint Research Centre's labelling report, in which they recommended certain formats for waste sorting labels under Article 12.1 of the regulation. And we'll actually come back to this a little bit later. And then in February, we had a decision approved by the Commission, which would exempt certain economic operators that use pallet wrappings or straps from the 100% reuse requirements in Article 29. And again, in this case, it was just recognised that economic operators may struggle to adapt to these requirements by 2030. So an exemption was granted in this case. And then last but not least, definitely not least, the highly anticipated guidance document and a fact document was published, I think, on the 30th of March. So I'll mention these documents again, especially the fact document. I think overall they provide some clarification, but probably not as much as everyone wanted. So just overall, as you can tell, we've updates happening every month at this point, and I think it'll get busier and busier. We're expecting implementing and delegated acts to be published as well over coming weeks and months. So there's just a lot to go through.
Yeah, and I suppose if I can chip in, Connor, like this is why regulatory tracking tools are probably necessary for a lot of companies, because sometimes it becomes quite a difficult task to track all of these. And Frida will talk about some of the national implementations as well and how important they become in that sense. So I suppose just to highlight the importance of the tools like C2P, for example, to make it easy for companies to track these updates.
Yeah, absolutely, Annie. Yeah, and just to move on as well now to some requirements that are coming into effect from this August. So obviously, we can't cover everything in the hour that we have, but I've picked out some provisions which we have received questions from our customers about. So I'm sure if they're of interest to our customers, hopefully they'll be of interest to many of you watching as well. So firstly, we have Article 15, which comes into effect from August. So this article outlines general obligations for manufacturers, and the article begins with Article 15.1, and it states that manufacturers shall only place packaging on the market that is compliant with Articles 5 to 12. And that actually, at this point, it's important to remember that most of these articles from 5 to 12 don't actually come into effect from this August. Most of them would apply from 2030 or later. So for now, from August, when placing packaging on the market, you need only comply with the requirements that are actually in force. And secondly, on Article 15, I'd just like to bring your attention to Article 15.5, which requires manufacturers to attach a type, batch, or serial number to the packaging or to the accompanying documentation. So basically, this requirement is to ensure traceability, primarily for the market surveillance authorities. Now, we do receive a lot of questions about this, actually, and the fact document published in March doesn't really expand on this requirement. It simply says that the manufacturer is free to choose between the type, batch, or serial number or another ID number. And it doesn't really expand on when a manufacturer may move this identification from the packaging to the documentation. Now, we do have the EU's Blue Guide that does provide some extra information on this. And for those of you watching, I always recommend the Blue Guide to our customers, as it's a very extensive document which provides comprehensive guidance on EU product rules and going to market and stuff like this. So page 60 of the guide actually advises that the identification may only be moved from the packaging in exceptional cases, and it may not be moved on purely aesthetic or economic grounds. And it's up to the manufacturer to make this assessment. And the guide also states that the identification element used shall be the same as the identification element used in the EU Declaration of Conformity for the packaging. So, and some customers also have asked us about using the product's SKU number as the ID number for the packaging. And on this, I would just advise caution, because I think it's the fact document says that you must ensure that the packaging itself is identifiable rather than just relying on the ID number for the product inside the packaging. So bear that one in mind.
And Connor, similar requirements also apply to other economic operators, right? Such as importers and distributors.
Yeah. So these importers, distributors, etc., these economic operators, essentially, they ensure that the manufacturer has carried out their responsibilities for Article 15 and Articles 5 to 12. And on top of that, if an importer or a distributor places packaging on the market under their own name or trademark, or if they alter the packaging that has already been placed on the market, they will actually assume the role of the manufacturer themselves under the regulation. So that's important to remember as well. So yeah, hopefully that clears up some confusion on Article 15. We could talk a lot more. It'd be great to spend more time on it, but time is limited, so I'm going to move on. So next, I would like to discuss the EU, the Declaration of Conformity, or the DOC. And this is a major topic for our customers at the moment, because again, these requirements come into effect from August. So everyone's kind of talking about this at the moment. So if we start with the basics, who is responsible? The manufacturer is ultimately responsible. And that's regardless of the fact that another economic operator, such as the supplier, may have had a hand or a part in preparing the DOC. So just remember, it's the manufacturer who is ultimately responsible. And as well, just at this point, I would like to note that it may not actually be completely clear-cut as to who is the manufacturer or the supplier under the regulation. Some of our customers have actually come to us and they've told us we're not sure what definition in the regulation that we fall under. And actually there's a whole section on the official guidance document that goes through the definition of a manufacturer and it explains when you may or may not fall under that definition. So it's definitely a source of uncertainty. So I just advise everyone to look at the definitions in the regulation under Article 3 and just make sure you're clear on which role you fill in the supply chain, like which economic operator you are under this particular regulation. And anyway, sorry, coming back to the DOC, if you are just a supplier of packaging, you are not required to prepare the DOC, but you are required to provide the manufacturer with all information and documentation necessary to demonstrate conformity. This is an explicit requirement under Article 16. And now secondly, what is required? So the DOC shall state the fulfillment of the requirements found in Articles 5 to 12, and it shall contain the model structure and information set out in Annexes 7 and 8 of the regulation.
But Connor, when you mentioned earlier that, many requirements of the regulation actually come into force at a later date, right? Or apply at a later date. So from August, the declarations of conformity need to only demonstrate conformity with the articles and the requirements that are in force from August. Is that right?
Yeah, that's correct. So, for example, Article 10 on packaging minimization doesn't apply until 2030. So there's no need at this point in 2026 to demonstrate conformity with this article because it's not in force. So hopefully that's pretty clear. And then moving on, I just like to deal with a slightly more complicated issue in relation to the DOC. So a basic requirement is that the DOC must be prepared for each packaging type, and that's a quote, packaging type. And according to the fact document, must be drafted at, and I quote again, the level where packaging has the same characteristics in view of the applicable requirements and the packaged products. Now, we immediately run into some difficulty here because there's no comprehensive definition or explanation for what constitutes a packaging type. So page 41 of the recent fact document does say that a packaging type refers to each packaging format or each packaging batch or series. So that's all they say. That's the only information we have. So it's something, but not a lot. So the crucial question then when deciding when a new DOC is required or how many DOCs you need is whether your packaging differs to an extent that they are considered to be different packaging types to one another due to, for example, their format or their design or their material composition. If they are a different packaging type, then they each require a different DOC because once you have a different type, their compliance with the regulation would differ to some extent due to the change in the packaging's characteristics, right?
Yeah, Connor, if I can stop you there, just because a question came in on the declaration of conformity as well. So while we're on the topic, we might as well address this. So if the question says, if I'm a manufacturer and I have packaging supplied to me by 5 different suppliers, would I need 5 different declarations of conformity?
So if the packaging supplied to you from each of these 5 different suppliers in terms of, for example, their material, their format, or their design, and they have different characteristics in relation to the requirements in the regulation, then yes, you will likely have 5 different packaging types. And in that case, you will need 5 different declarations of conformity, right? And before moving on as well, I would just note that the packaged product you have inside the packaging can also impact the packaging's conformity with the regulation. So again, The most obvious example of this would be Article 10 on packaging minimization, which requires manufacturer or importer essentially to minimize the weight and volume of the packaging where possible. So as you could imagine, the potential weight and volume of the packaging is directly impacted by the product inside the packaging. So for some articles, especially Article 10, you must consider the product's impact on the packaging's conformity as well. So there's a lot to consider, and I know it's been a source of confusion. We could talk a lot more about it, but feel free to leave any questions in the chat, or we can get to them later, or we can come back to you after the webinar. And just finally on this slide, another point which has been asked about the DOC from our customers has just been about the signature. So it's to be signed by an individual working for the manufacturer or the authorized representative. And the employee's function in the organization should also be indicated, and it may be signed by a manufacturer established outside the EU. And then moving on, just the last thing on the DOC, I would just like to touch on cases where the packaging may be subject to more than one EU regulation or directive. Again, this is something our customers have come to us about frequently. And to be fair, it's actually explained fairly well in the regulation. So Article 39.3 states that where packaging or the packaged product are subject to one or more than one Union Act requiring a DOC, a single DOC shall where appropriate be drawn up in respect of all such Union Acts. So the manufacturer is given a choice here. The manufacturer can decide what's more appropriate, a single DOC covering multiple Union Acts or separate DOCs. It's up to the manufacturer to just deem what's more appropriate for them for their own internal compliance process. And just before I finish and hand you over to Ruin, I'd just like to give you a quick overview of the current status of Article 12 on packaging labelling, because I know labelling is something that's always interested our customers, and I'm sure many of you watching as well. So first of all, the way sorting labelling under Article 12 won't be coming into effect until 2028 at the earliest. And for now, we have a JRC report published in January, which I mentioned earlier. This report will inform the content of the implementing act that will be published this year for Article 12.1. And it will contain the label designs for the way sorting labels. So it seems when you look at this report that the JRC have softened their language a little bit on the use of both text and colour on the labels. We discussed this, I remember I think it was September in our last webinar. So they still favour text on the labels, but they do at least acknowledge that it would cause difficulties for economic operators going forward, who might have to translate the labels into over 20 member state languages. So you can see on the slide now, hopefully, one of the final label proposals published by the JRC. This is the proposal that doesn't contain text. You can find this in their January report. And so for now on labelling, we just wait and see, because the Commission is required to publish this implementing act by the 12th of August this year. So that will finalise what the labelling designs will be.
Thanks, Connor. And then, how will these harmonized EU labels impact the national labeling requirements that are currently in force in certain EU member states?
Yeah, so the EU Commission has been very clear. So from the EU's point of view, the national labelling requirements will no longer be permitted once the EU requirements come into force. So for example, the Spanish, French or Italian, national labelling systems should all be repealed over the next couple of years. Now, whether these countries actually comply with this is another question, but we'll wait and see on that.
Yeah, true. Thanks, Connor. I think we'll hear more on that from Frida as well, how various member states are dealing with the implementation of the regulation. It was very informative. So we've covered the status of the regulation and some common questions, but like if we look further, I suppose there are some unresolved or unclear issues that exist, as it all usually happens, I think, with regulations that of such impact, such as the packaging regulation. So I will pass you over now to Ruan, who will speak about some operational gaps for businesses and kind of what aspects of the regulation needs more clarity. Ruan, please.
Thanks, Annie. Yeah,
you.
so as we know, the PPWR is a really ambitious and wide-reaching piece of legislation, which has inevitably left some grey areas and also led to some real concern across the industry, even with the publication of the guidance and FAQ document. Now, this was first raised by the industry group Europen, who did note that the guidance, while a necessary step, doesn't yet provide the legal certainty that's needed by businesses. So they're actually calling for some high-level dialogue between policymakers and also industry leaders in order to resolve these issues. And interestingly, actually, then just last week, a sort of coalition of some major industry CEOs, which included Coca-Cola, Heineken, Mondelez, actually signed a petition letter urging the Commission to postpone the enforcement of the PPWR. And they actually highlighted in their letter some unresolved questions around PFAS restrictions and also plastic shrink wrap as well. And then also last week, the Czech Republic actually circulated a sort of like an informal policy document, also requesting the Commission to provide more guidance on exemptions for various packaging solutions. So I guess to kind of illustrate what these operational gaps look like or where they are, we'll start with PFAS restrictions. So as we know, the regulation sets clear PFAS restrictions for food contact packaging from the 12th of August, even though a harmonized testing methodology is not yet in place. So to kind of bridge that gap, the Commission did suggest in their guidance to use a sort of stepwise testing approach in which you first screen for total fluorine, then confirm whether excess fluorine is organic, and then finally use a TOP analysis to check compliance with the concentration limits in the regulation. Now, the issue here is that this method is not actually legally binding, which means that member states are not required to follow this specific method. And in practice, down the line, this could lead to national authorities in these member states using slightly different approaches or various approaches to the suggested method and potentially reaching somewhat inconsistent results on packaging units that are actually identical. Also important to note that the guidance outlines that there will be no transitional stock exhaustion period for packaging. So this means that there's no sell-through window, and any non-compliant packaging already in a company's inventory can't be placed on the market after the 12th of August. And now this could have a significant financial impact on businesses, particularly if they have non-compliant, PFAS non-compliant packaging, because they may have to rework packaging or even write off or dispose of non-compliant packaging either.
And Ruan, if I can interrupt you there. So without this harmonized PFAS testing methodology, like what is that businesses can do to prepare for these upcoming PFAS requirements or restrictions in August?
Yeah, and I suppose it's kind of something that I'll mention a few times, but preparation really is key. You know, we know that this will apply from the 12th of August, and August is just around the corner, really. So preparing as best as possible. May be useful to even secure, you know, PFAS-specific confirmations from packaging suppliers, for example, making sure that these confirmations are supported by any recognized standards available. And also, if there are specific testing approaches used for the packaging, to ensure that these approaches or methods are clearly recorded in the documentation. It may also be useful as well to have a sort of internal system as well to kind of track any packaging that may have a PFAS exposure risk as well. But overall, it's just really important that, I guess, the sort of lack of a harmonized testing methodology is not misinterpreted as any sort of delay in the application. So being kind of proactive with your preparation really is key here.
Yeah, and just kind of collecting all the data, which I suppose we have been mentioning a lot in all our webinars and compliance roundtables, which, it's just very important. Thanks, Ruan. So just to ask another question about, any other requirements which we are still awaiting final technical guidance or methodologies for.
Yeah, so similar, I guess, to PFAS restrictions then, packaging we have the recyclability of packaging. So packaging placed on the EU market, as we know, must adhere to the recyclability requirements also from the 12th of August, even though the actual full delegated act, which will set out the design for recycling criteria, is not actually expected until early 2028. Now, also in the sort of absence of this delegated act, the Commission indicated in its guidance that Standard 13428 sort of acts as a relevant reference point for packaging design and also general preparatory efforts. But this was created under the previous packaging directive framework. So while it can definitely be used in the interim to guide businesses, it wasn't created under the current packaging regulation framework, and therefore it doesn't automatically create a presumption of conformity under the PPWR. Now, there is a bit of relief provided in that the formal conformity assessment for recyclability under the regulation is deferred in this case. So you need to comply with the conformity assessment once this delegated act is adopted, which, as mentioned, will not be until at least 2028. But yet again, similar to PFAS restrictions, businesses should really be looking at this time before August now as sort of a preparation phase, making sure that you're reviewing your packaging design, make sure you're focusing on recyclability principles, and also aligning with these existing standards where possible or, to the best of your ability. So then for minimum recycled content under Article 7, the main recycled content targets apply from 2030. And a lot of the operational detail is still pending around this, which is again a kind of common thread that we're seeing throughout. So the Commission is actually expected to publish a number of implementing and delegated acts by the end of the year, by December. These will include methodologies for calculating recycled content, rules for third country equivalents, and also the criteria used to actually assess recycling technologies. Now, in terms of exemptions, a sort of key challenge is that some exemptions are only available where companies can really clearly demonstrate that either no suitable recycling technology exists, or alternatively, that such technology is not yet available at an industrial scale. Now, this does create this is quite evidence heavy, and it's an evidence burden for businesses, particularly smaller businesses, as you really will need a robust technical file and also data to substantiate your exemptions. Finally, then, the timeline as well is also slightly compressed, particularly for sectors relying on non-PET plastics, because there will be a 2028 derogation review. So this will take place only really shortly before, or potentially sort of alongside, the broader recycled content requirements, which, as we know, become applicable from 2030, which does leave limited time for businesses to kind of align their packaging if exemptions are either narrowed or removed. So moving on to extended producer responsibility now. The initial implementation roadmaps flagged that the Commission was expected to publish an implementing act earlier this year. in February on EPR registration procedures and also reporting formats. But to date, this has not actually yet materialized. So this implementing act is expected to establish, obviously, the registration format in national registries, and the exact reporting format, the granularity of data, covered packaging types and categories, and also the thresholds for simplified versus detailed reporting as well.
But Ruan, just to clarify for the audience, the regulation doesn't really create one EU-wide EPR system, right? Because like the producers will still sort of face separate compliance in member states.
Yeah, exactly. Yeah, so the national EPR systems will continue to handle sort of core operational work, so registration, pro contracts, reporting, that sort of thing. So the PPWR itself doesn't replace these national systems. Instead, it kind of overlays them with the harmonized rules. So like the formats and conditions in which the national systems will operate. So I guess the overall aim is to bring greater consistency amongst the systems, but the aim is not to create a single or kind of central EU register or system. So in practice then, definitely country by country compliance and also communication with national PROs really does remain essential, particularly for businesses that are selling in multiple member states, because they will still have to comply with the kind of distinct national EPR environments kind of. So then overall, the PPWR framework is definitely taking shape and moving in the right direction, but we are still waiting on the key implementing and delegated acts to really kind of fully flesh out the regulations requirements. You know, we're still waiting obviously on the EPR registration and reporting, harmonized labeling formats, design for recycling criteria, and also recycled content calculation. But there is also kind of an evolving approach to the guidance surrounding the regulation. We know that the FAQ document is intended to function as a living document, which does leave some room for refinement and also hopefully continued incorporation of industry input. But what's also clear is that there are obvious gaps in the scope just due to the nature and complexity of the regulation itself. So many packaging use cases are not fully yet addressed, so interpretation will often need to be done on a sort of case-by-case basis for some businesses. Now, given this, and as Connor previously mentioned, it is useful to consult sort of broader EU framework materials, specifically the EU Blue Guide, just to kind of help interpret some of these core regulatory concepts. And I think I also seen a question in the Q&A earlier on how to access the EU Blue Guide. So it is easily accessible online if you just, on the actual EU Commission's website, if you search for EU Blue Guide 2022, that is the most recent version, and it's available for you to view and download there. But yeah, overall, preparation really is key. So a lot of the packaging decisions that are made now will really shape a business's ability in the future to comply with the PPWR requirements, especially as the framework in general really does continue to develop as well.
Yeah, thanks. Thank you, Ruan. Yeah, I suppose, key takeaways, like do what you can now to prepare, collect all these data from suppliers or from your kind of do a stock take of what you have at hand in terms of packaging and how your practices are set up, and then just monitor whatever regulatory developments there might be to get more clarity. And you have, like yourself and Connor have mentioned the guidance documents, the FAQ documents as well. And I think often we see from like the highest visited pages on in C2P as well are often these guidance documents because they provide more clarity rather than the actual regulation. So it's also important to know that we always add these into C2P as well. So there's also a good way of tracking those, as well as, you know, all the regulatory commentary, expert commentaries, and regulatory updates and use and analysis comments that we input. So I think that's also kind of helpful to prepare, to just kind of see these early signals of something's coming up, and you'll prepare a little bit better. Thanks a lot, and we'll move on to Frida now, who will give us an overview of the member state implementations of the regulation. Frida, please.
Thanks, Annie. So firstly, to set the scene, as a regulation, the PPWR is directly applicable in all EU countries. However, several measures within the regulation require implementing legislation from EU countries to fully enter into force. Therefore, it is very important for businesses to ensure their packaging is in compliance with both the EU regulation and the relevant national legislation. So really, we're at a transitional point in time where EU countries are in the process of drafting PPWR implementations, as well as repealing existing legislation which is in conflict with the regulation. So what do implementations need to include? Here we have the list of measures EU countries must develop legislation for, and it includes the need to establish competent authorities for surveilling compliance. They must establish appropriate waste management measures for treating compostable packaging. They must provide authorizations for PROs. They must also establish penalties for non-compliance with the regulation. And they must also set mandatory collection targets. And as you can see from the slide below, there are a few deadlines that member states need to achieve this by. Now, in addition to the measures member states must develop legislation for, there are several legal requirements member states can choose to develop legislation for. Member states can choose to provide exemptions to certain reuse obligations. They can also choose to retain certain elements of their existing systems for the management of household and commercial packaging. They can also choose to establish higher minimum waste prevention targets than those that are set in the PPWR. So for instance, they can set higher recycling targets or reuse targets. They can also establish EPR costs for waste treatment, such as cleaning and transport fees. They can also establish eco-modulation criteria for calculating producer fees. And they can also choose to expand deposit and return systems to include packaging other than beverage containers. Additionally, they can require the appointment of authorized representatives. They can make membership of a PRO mandatory. And finally, they can allow distributors to form groups for the purpose of fulfilling their obligations to meet reuse targets for beverage containers.
Thanks, Rita. I was just going to say, I think as we are discussing national implementations and all of these, I think it becomes even more crucial just to follow all these developments, because I think on the EU level, sometimes perhaps it might be a little bit easier to track certain regulatory developments, whereas then when you're branching out into 27 different countries with various languages and various legal systems in there, that's when I suppose it becomes even more helpful if you have something to help you monitor all of these early drafts and then how these drafts progress through that. So I think you will address also which countries have actually done much and which haven't. So I'll let you get to that.
So here we have an overview of the current status of implementations. As you can see, only 14 countries have begun drafting legislation to transpose the regulation. So an important point to make here is that many of these drafts are only partial implementations. So we do expect more developments from the countries on the green list. In terms of the other 13 countries, no drafts of any sort have been proposed. So again, we are expecting a high volume of proposals in the coming weeks. Lastly, since the regulation is classified as relevant to the EEA, the EEA is in the process of reviewing the regulation to see if it should be incorporated into its EE agreement. There are many steps left in this process. So again, it may be some time before we have an answer on this. However, I would say since the previous EU packaging directive was incorporated, it does seem probable that some aspects of the regulation will be.
And Frida, so this is a question that often comes up from our customers as well. So what happens if member states do not adopt implementing legislation, especially ahead of, upcoming deadlines?
Yes, that's a good question. Essentially, the regulation has direct applicability, so you need to plan to be ready for that, regardless of whether a country has an implementation in place. What I would say is businesses need to be very careful in that when trying to comply with the regulation, that they assess what national implementation is in place and whether it's outdated information that is in conflict with the regulations. So you just have to be very careful when looking at national packaging legislation that it is up to date going forward. Now looking at individual state implementations, firstly I want to start with France, which proposed a partial draft implementation late last year. Since France already has a well-established packaging EPR system, which is spread across several pieces of legislation, it is anticipated that France will aim to transpose the EU regulation through multiple amendments to its environmental code and its circular economy law, for instance. Looking at the current draft, it isn't a comprehensive implementation. Many points which need legislation are absent, but it does contain a number of notable proposals. Mainly, it proposes the introduction of a requirement for packaging producers to obtain a unique identifier before marketing packaging that is subject to EPR requirements. It also requires the appointment of authorized representatives for producers that are based outside of France. And it proposes the repeal of legislation prohibiting the marketing of EU-compliant packaging that doesn't meet France's current labelling obligations, which does seem to be a very strong reference to the Triman logo. And lastly, it proposes the introduction of a requirement for online marketplaces to ensure a packaging sold on their platforms is compliant with EPR requirements from the beginning. And just a reminder as well, the French EPR scheme for packaging will be extending to professional packaging on the 1st of July this summer. So that is still going ahead despite the recent changes at an EU level. Now moving on to Germany. So in comparison to France, Germany has released a more comprehensive draft proposal, which was last updated in April. Interestingly, tomorrow, the Bundestag will be holding a hearing on the draft. So we will have more information on whether Germany will be updating the draft further, which was recommended by its Federal Council recently, and whether Germany is still on target to enact the implementation by August 12th, which was a deadline that was set by the German government. Looking at the draft specifically, the German authorities have stated that with this draft, they aim to reduce bureaucracy and ease German businesses into the PPWR framework. Therefore, the draft does retain many elements of Germany's existing EPR system, including the position of the Central Agency Packaging Register, system participation and the dual system concepts, as well as the obligation to submit declarations of completeness to the Lucid Packaging Register. The draft also proposes the introduction of the following changes. So it intends to expand the list of packaging which is subject to system participation. It aims to expand the duties of the ZSVR, to introduce an approval obligation for EPR systems for packaging which aren't subject to system participation. It also proposes extending EPR obligations to producers of packaging not subject to system participation. It also intends to establish new recycling targets. And lastly, the draft defines new administrative offences. But crucially and interestingly, it does not contain penalties for non-compliance yet anyway. So before I finish up, the last country I'm going to go through is Poland. So Poland is another one of the few countries to have proposed a comprehensive implementation. So the draft itself is extremely detailed. However, it can be summarized into the following points. It does propose enacting the polluter pay principle. It does intend to introduce packaging fees, which will increase until the year 2027. It does contain a derogation for micro enterprises on single-use plastic restrictions. It does request mandatory registration in the DOP and reporting on packaging volumes. It establishes requirements for authorized representatives. For submitting reports, there are 2 compliance deadlines, one for the 31st of January and another for the 15th of March annually. It also sets EPR obligations, and it has more exemptions for packaging, which should be under substance limits for lead, cadmium, mercury, and hexavalent chromium. And they have clarified that more details on this exemption will be forthcoming in further legislation. And Poland is one of the few countries that gives us an example of the penalties they intend to implement for non-compliance. I have tried to convert this number, and I think it's 230,000 euro. And it also establishes measures for competent authorities. And lastly, if you do want more information on the status of implementations in each individual member state, Compliance and Risk will be releasing a white paper on this in June. So follow our website where it'll be available for free download. And with that, thank you for your time, and I'll pass you back to Annie for questions.
Thanks, Frida. And thanks everyone for your attention. We have the floor open for the Q&A session. And if you have any questions that you haven't asked yet, please put them in the Ask a Question widget to the left side of your screen. And we already have quite a few questions that have come in already. And seeing that we only have about 7 minutes left, I will maybe pick 2 or 3, and then as we said, we will come back to you directly afterwards to answer the questions. So one of them that I was looking at here was, you mentioned that the EU Commission has adopted an exemption from reuse targets for pallet wrappings and straps. Are there or will there be any other similar exemptions? I think Connor was the one who was talking about this. Connor, if you could.
Yeah, thanks, Annie. So as far as I'm aware, not currently. I don't think there is a planned exemption from reuse targets for anything else yet. Now, the Commission does have the power under Article 29 to issue further exemptions if there are constraints, like economic constraints in certain sectors that would justify such an exemption. But as far as I'm aware, currently, no, it's just the pallet wrappings and straps currently.
Okay, thanks, Connor. There's another one regarding PFAS non-compliant packaging. So what happens to packaging stock we already have? Can we still use or sell it after the August deadline if it was produced before then? I think this was something Ruan was talking about. Ruan,
Yeah.
you could answer, please.
Yeah, I'll take this one. So yeah, the rule depends on when the packaging is placed on the market and not when it was made or produced. And as we already know, there is no sell-through period. So packaging that's physically placed on the market before the 12th of August can stay in circulation, but any packaging that's placed on the market from that date must comply with the PFAS restrictions, even if it was produced earlier than that. Yeah.
Okay, thanks, Ruan. And I suppose maybe one last one. What is something you think we need to watch out for in the national implementations of the regulation? I suppose this is for you, Frida.
Yeah, so one thing I think people need to be aware of is, especially when looking at implementations, is that for countries that have existing EPR systems, a lot of the time there would have been a narrow scope of packaging that was included in that. But with the EU regulation, the scope of packaging for many countries has increased. So generally speaking, those existing systems will automatically have to cover the packaging that is in the larger scope of the regulation. It might not be well defined in implementations, but that is the situation. So for example, the French and the German schemes, they had narrow product scopes, but now those scopes have increased to include all those that are in scope of the EU packaging regulation. So just to bear that in mind, it might not be clear, but that is the case.
Yeah, great. Thanks, Frida. There's actually quite a lot of questions here, but I think we're coming up to the hour, so we will come back to you directly with some of the answers as well. Thanks so much for all three presenters, and thank you for tuning in with us today. We really hope that you found today's presentation helpful, and we look forward to seeing you in our other webinars as well. And as we mentioned, you can check out the resources section on our website, and you can stay updated, and you can access a lot of our white papers and blogs and webinars, and you can watch back some of the webinars as well. And we have a lot of upcoming content, including on packaging. So Frida mentioned one white paper there that will be updated in June, and then another one is a white paper on packaging labeling legislation in Europe that we will be updating in the coming week or maybe a little bit later. And then our next webinar is going to be about e-commerce compliance, new rules on green claims, product safety and transparency, and that one is scheduled for Wednesday, 20th of May. So maybe we'll see you there. But thank you again to all of you for tuning in with us, and we will see you next time, hopefully. Thank you. Bye.